Today's Ask a Pro webinar. Today we're talking everything foreclosure sales and bidding strategies. My name is Casey Hicks and I'm a shareholder here at Weltman, Weinberg & Reese, sitting in the Chicago office, and I'm also the chair of our real estate default group. Today I'm joined by two of my colleagues, Ricardo Johnstone and Megan Katz. Ricardo, good morning. Could you introduce yourself to the folks out there today?
Yes, good morning. I'm Ricardo Johnstone. I'm in our firm Cincinnati office. I've been with the firm for 12 years now, and I'm licensed in Ohio and Kentucky.
Great, thank you, Ricardo. We're also joined today by Megan Katz. Megan, could you introduce yourself?
Yes, hi, my name is Megan Katz. I am licensed in the state of Ohio. I'm an associate attorney with Weltman. I've been here for about 3.5 years, and I handle the northern half of the counties in Ohio for foreclosures.
Great, thank you, everyone. Before we get started, I'd like to take a moment to go over a few housekeeping items. As a reminder, today's webinar is an interactive webinar, so please submit your questions through the question button in the control panel. Questions will be addressed live during the presentation. If we do not get to your question, we will be sure to reach out to you afterwards to get you an answer. At the conclusion of today's session, a link to the recording and a copy of the presentation will be sent to all attendees. Also, there will be a short survey on the screen at the conclusion of the webinar. Please take the survey and share your feedback. We greatly appreciate hearing your opinions on our webinars, and if you have any topics you would like us to address in a future webinar, please let us know that as well. All right, without further ado, we'll go ahead and get started. And first state we'll be discussing is Ohio. So Megan, I'll throw it over to you.
All right, thank you so much, Casey. So like I said, I handle the northern half of Ohio counties for foreclosures with our department. So I'm going to talk you guys through a little bit about the timeline of foreclosures for foreclosure sales and just some of the strategies that you might want to employ when you are getting a sale for a property. So just speaking kind of generally, in Ohio, foreclosure sales can be brought by a junior or senior lien holder. So regardless of what position you're in, as long as there's a delinquency and you have a foreclosure decree, even if there's a couple liens ahead of you, or if you're the senior lien, you are able to bring a foreclosure sale in Ohio. For Ohio sales, they're conducted either through the sheriff's office or through a private selling officer. Private selling officers are not always allowed in every single county, and sometimes it's magistrate specific. For example, if you've ever worked in Cuyahoga County, you know they have some picky magistrates and some of them don't allow PSOs. But that information, if you ever have any questions about that, we'll obviously give you that information before we get into the sale process. For Ohio foreclosures, anyone can bid at a foreclosure sale. So just because you brought the judgment in a foreclosure and are taking it to sale, that doesn't mean you have to bid. Conversely, if you have a lien on the property but somebody else brought the sale, you can bid if you want to. So really, you can decide what you want to do, what makes the most sense, and we'll talk about situations where you might want to bid or not bid a little bit later. So I want to take you guys through a little bit of a timeline of the foreclosure sale process in Ohio. And I want to start out by talking a little bit about the pre-sale measures that we take. So you have a judgment in foreclosure. What do you do next? The first thing we want to do is order a precipice for order of sale. When we get the judgment, we immediately proceed with doing this and file this document essentially as soon as possible right away. Now, this is just a request for the court to order the sheriff's office to set sale dates and just kind of get the process started. Once we file that paperwork, the property is going to go through an appraisal. Now, this is conducted by a disinterested party to determine the value of the property for the auction, especially if this is a mortgage foreclosure. The appraised value of the property is going to come into account when you're determining the minimum bid and how much the property is going to have to be bid for at the sale. Once we have the appraisal and we file the precipice, then the county is going to come back to us and give us sale dates, and they're going to give us two. One for the first sale, one for the second sale in the event that on the first date the property is not sold, and that second sale date is usually anywhere from 7 to 30 days after our first sale. And we get these dates, usually the first sale is like 30 to 45 days in advance, so we have enough time to notify all the parties. So once we have those sale dates, our office will go ahead and file our notices of sale. This is done by filing advertisements for sale in the local papers to just kind of notify the general public. We also will file a notice of sale with the court and serve all the named parties. So the property owners, other interested parties, other lien holders that have been named in our court proceeding are going to get a notice from the court from us, letting them know of the date and time of this sale. So now we have our sale dates. What do we do at sale? What is going to make the most sense for us? So once we get a sale date, our office will reach out to you requesting bidding instructions. So we need to know how we're going to proceed at sale and what you want to do. Bidding instructions, we'll send a form with all of the different information that you might need to determine how much you want to bid at sale. And we typically like to get those back to our office within 5 days of the sale date, just so that our office can enter everything online. So if you have any questions and you're reaching that 5-day mark, please reach out to us so that we can help you with this. So like I said, anybody can bid at the sale or not bid, even if you're the plaintiff or a lien holder defendant, regardless of what position you're in. There are some requirements that you want to keep into consideration when you are looking to bid at a property. So for a mortgage foreclosure sale, the minimum bid at the first sale date is determined by 2/3 of the appraised value. So for example, let's say the property is $300,000 appraised value. Our minimum bid requirement is going to be $200,000. And they say that attorneys are not good at math. I just dazzled you with my division right there.
Great job, Megan.
Thank you so much, Casey. I was hoping someone would notice. So like I said, the first sale date, 2/3 of the appraised value, we'll have those calculations for you on our bidding instructions. If the property does not sell at the first sale date, we'll move it to the second sale date that we were given by the county. And at this sale, there's not going to be a minimum bid based on the appraised value. So technically somebody can bid whatever they want. However, it is important to keep in mind that whoever is a successful purchaser at the second sale, well, for any sale dates, but especially at the second sale date, even if there's no minimum bid, you're still going to be on the hook for court costs and unpaid taxes. So that's always something you're going to have to keep into consideration. Now, if we have a tax foreclosure sale, that's going to be a little bit different, because rather than having the minimum bid be determined by the appraised value and dividing it by 2/3 or 2/3 of the appraised value, the first and second sale dates, that opening bid is going to be determined by the amount of taxes that are due as well as the court costs. So in most situations, unless somebody owes an insane amount of taxes on a property, the tax foreclosure sales are going to be most likely having a lower minimum bid. So that's something you want to take into account, whether you're, you have tax certificates or you are participating in a tax foreclosure, the minimum bid is going to potentially be a little bit smaller.
A question for you, Megan. In your experience, how many sales are actually going to that second sale date?
I guess it depends. I think in general, property values in the last couple of years have been a little bit higher. And I think also there is the trend of people wanting to buy a foreclosure property for a lower amount and then flipping it. I get a lot of calls from people wanting to do that. So, it's not every single time that it's successfully sold at the first sale, but I think that definitely helps us get more successful bids on that first sale date. Sometimes if the property is just in really bad condition, there are situations where it does go to the second sale, but in my experience, it seems like a good amount of times it's successful at the first sale date.
Okay.
But it always kind of depends on the circumstance. So that's just kind of the bidding instructions at a bird's eye view, but there's some strategies that you might want to think about when you're determining whether it makes sense for you to bid at a foreclosure sale. So the goal of bidding at a foreclosure sale and just the sale in general is to make you whole and to have the delinquent loan that a borrower had, be made whole from the proceeds of this sale. So ideally, what you want to do and think about when you're bidding for a sale is to bid an amount that's going to cover that. However, in certain situations, there are going to be certain amounts that are going to be paid ahead of your lien from the proceeds of the sale. And when you're looking to bid, you want to take into consideration those amounts. So for example, if you have a $50,000 debt, you can't just bid $50,000 all the time, because there's going to be things that are going to be needing to be paid ahead of you. So you want to take those into consideration. For example, court costs, unpaid taxes, conveyance and deed recording fees, PSO and sheriff fees, depending on the situation, and senior liens are all going to be paid ahead of your loan from the proceeds of the sale. And again, we'll have that information included in our little bidding instructions. We'll have the delinquent taxes and fees and everything like that, so you can get an idea of what's going to be paid ahead of you. So when you're determining what's going to make the most sense for you to bid, you want to take these into account, potentially add those to the bid that you're going to be submitting, because you want those are all going to be paid ahead of you from the proceeds. And, if you only just bid your amount, that's just going to go to the amounts that are paid ahead of you. So there are some situations, like I said, you don't always have to bid at a foreclosure sale. That's one of the benefits in Ohio. You can have that option to do that or not do that. And there are some situations where it might not make sense for you to bid at a foreclosure sale. For example, like I said, there are, it seems like property values the last couple of years have been a little bit higher in Ohio. And sometimes that means the appraised value of the property is going to be, a little bit higher. So for example, in our example, where we have a $200,000 minimum bid, let's say our amount that we're trying to get covered is $50,000 for our delinquent loan, maybe a couple $1,000s other for taxes and court costs. If the minimum bid that somebody is required to pay is so much higher than the amount that's past due for us and the amount that's going to make us whole, any bid that anyone submits for this sale is automatically going to cover us because they can't bid lower than that minimum bid. So, if the $200,000 is automatically going to cover our $50,000 lien, even take into account everything that's going to be paid ahead of us, it's not going to make sense for you to bid because anything is going to cover it. Now, if in the situation, maybe the first sale, someone doesn't bid on the property and it goes to second sale date, then we can touch base and reconvene and determine what your bid is going to be at that time. But if the minimum bid is so much higher, it's not going to make sense for you to bid. On the other end of the situation, let's say the property has fallen into disarray and it's appraised for a very, very low amount of money. There's a senior lien that's also, a large amount of money that's owed that's going to be paid ahead of you, and you have a large balance. If you are the successful purchaser at the sale, you don't want to pay, a large amount of money to cover everything else that's going to be paid ahead of you for a property that might only be worth like $30,000. So unfortunately, in those situations, you're not going to be made whole anyways, and you're going to be stuck with a property that doesn't have a lot of equity. It's not going to make sense for you to necessarily bid. So that might be a situation where you're just going to have to let it, see what happens and, hope that a little bit of your loan might get paid, but it might not make sense for you to take on that property by bidding on it. So those are situations where it might not be the best to bid at a sale. And those are, again, if you have questions about any of that, our office will be happy to answer questions and bounce some ideas off of you for what makes the most sense for your situation. So now that we've had a sale, we've bid or maybe not bid at the property, now we have our post-sale activities. Now this first bullet point is something that is specific to Cuyahoga County, which I have the pleasure or sometimes displeasure of having in my case, my caseload. So Cuyahoga County has a quirky little rule where after you have a sale date, you have to file what's called a motion for supplemental distribution of proceeds. Now, when we file a judgment entry, the only amount that's listed in there for the distribution is the principal and the interest. But there are other costs, as I'm sure you all have experienced, things like property inspections, property preservations, escrow advances, things like that, that are recoverable in a distribution of proceeds from a sale, but are not reflected in the entry. Because Cuyahoga County does their own confirmation entries, they require us to file this motion and affidavit supporting us to include any additional advances or recoverable amounts that should be reflected in the confirmation. So within 20 days of the sale, we have to file a motion and affidavit with supporting evidence to speak to the additional recoverable funds. Now, Cuyahoga County is pretty strict with their 20-day rule. If there's an extension that's needed, we can attempt to do that, but it's really best practice to get this in as soon as humanly possible so we don't have to rely on getting an extension. So we are going to be in contact with you immediately after the sale date to make sure we get that information. If there aren't any recoverable advances, that's fine. But we want to make sure we get that in prior to the 20-day mark to make sure that we can recoverable the amounts that are recoverable for you. So once we have the purchase, and if it's not Cuyahoga County, the next step is looking to the confirmation of sale. Now, the confirmation of sale is a court order that essentially confirms the sale, distributes the proceeds, and lists the order of distribution for all the interested parties, extinguishes all of the liens on the property, orders the sheriff to issue a deed and a writ of possession. Now, the confirmation is also noteworthy because it marks the redemption cutoff for the borrower. Typically, a borrower would have the right to redeem the property and undo the sale and basically, pay the arrears that are owed in full plus poundage and interest. Once the confirmation is official on the docket, this right and ability to do that for the borrower is cut off. So they're no longer able to exercise their right of redemption once the confirmation is made official. And we will, collect all the information that needs to be reflected in the confirmation entry and file that with the court, unless if it's Cuyahoga County, because they like to do their own. Once we have the confirmation of sale, that's when the distribution of the payment of the purchase of the property is made either by us or the third-party purchaser, and then the deed is executed to transfer title to the property to the new owner. So that's just kind of the foreclosure process, the sale process for foreclosure in Ohio in a nutshell. But there are some unique situations that I just want to touch on very quickly before we move to Ricardo and Casey states. So typically, like I said, in a confirmation entry, when there's a confirmation, all the liens on the property are extinguished as a result of the sale. There's no liens that remain on the property under normal circumstances. However, according to Ohio Revised Code section 2329.20, if you are a senior lien holder in first position on a property and you file in your answer when you're, prior to judgment, and you exercise your right under this statute and you say you want your property, the property to be sold subject to your first position lien, that kind of throws a wrench in our typical formula. And that allows the property, when it goes to sheriff's sale, to be sold subject to that first position lien. Now, what does that mean for our purposes? Rather than the property being sold and the liens being extinguished, this first position lien is allowed to remain on the property through confirmation and transfer of title to the new owner. The proceeds of the sale are not paid in lien priority to this first position lien holder because they're asking the lien be remaining on the property, so they're not getting paid, therefore it's not getting extinguished. Everyone else just gets paid in the next order. Because of that, because you're transferring a property with a lien on it, the minimum bid at the sale is not 2/3 of the appraised value, but 2/3 of the difference between the appraised value and whatever the unpaid balance is of the senior lien holder. And don't ask me to do that math because I can't do that in my head if it's a little bit more complicated. But those are situations that do kind of complicate things. And as soon as we get an answer from a senior lien holder and we see that language being exercised, we reach out and make sure that that's what they're asking for us to do. And then we contact our clients and let them know so that prior to judgment, they are aware of this so that they can plan accordingly, because the 2/3 of the difference between the appraised value and trying to sell a property with a lien on it, it's definitely going to make the situation look a bit different for how you want to proceed. So that's just something you want to keep in mind in those situations when they occur. So there are also just a couple of things I want to mention about taxes and tax certificates. Now, like I mentioned before, tax certificates and taxes do have priority over our mortgage liens, even if the certificates are in existence after our mortgage. So typically it's like first to record, that's the priority in Ohio. But if a tax certificate exists or there's unpaid taxes, there's really nothing we can do about the priority. It's just how it works in Ohio, and they get paid ahead of our lien. So in tax certificate sales, similar to tax foreclosures with the treasurer, they usually set a lower bid amount because the unpaid taxes amount is going to typically be lower than the unpaid mortgage balance. In some situations, so that's going to put a lower minimum bid, which potentially could make it more difficult for the purchaser to bid an amount high enough for you to pay your unpaid balance for the mortgage holders. But there are some situations where we can kind of work around that and help you kind of avoid the tax foreclosure going to sale. So sometimes the mortgage has provisions that might allow advances to be paid for unpaid taxes to avoid a tax sale or to preserve your interest in the property. There's certain provisions that allow you to do that. So, and if you don't want the property to go to foreclosure in a tax sale, then you can reach out to the tax certificate holder or the treasurer and pay the unpaid taxes and collect them as advances and bring those in your own foreclosure and just recover those that way so that you can be made whole, bring the foreclosure as a mortgage foreclosure and not have to worry about the tax certificate priority and having it be sold at a potentially lower minimum bid amount. So that's just a little bit of a workaround in situations if you're worried about that or worried about your lien being made whole, that we can work with. There are also, like I said, if a senior lien isn't pled subject to, typically the senior lien holder is paid in the order of their priority from the proceeds of the sale. So if you're in first position, you get paid first unless if you plead subject to. If you are involved in a case where, let's say, you're named and you didn't bring the foreclosure judgment, some other lien did, we can still bid at those sales. We can still purchase the property or attempt to do that to, make sure that our interest is paid whole, even if we didn't bring the foreclosure judgment. The only thing that you want to keep in mind when this happens is that if you're the non-judgment creditor, so if we didn't have a judgment in our clients' names, we have to pay a deposit prior to the purchase of the sale. And that's why we want to make sure we're in communication, getting those bidding instructions, a couple of days prior to the sale, so we can also collect your deposit, put everything in place to purchase at the property. That's just an additional consideration we have to keep in mind if you're participating in somebody else's foreclosure sale. So I believe that's all that I have for the foreclosures. If there's any questions at the end, I'd be happy to address them at that time, but I'm going to hand it over to, I believe, Ricardo now to talk about his states for foreclosure sales.
Good morning. So Kentucky sales, they are very similar in many ways to Ohio sales. So the biggest difference is that in Kentucky, the sales go through what's called a master commissioner. They're appointed by the circuit court judges. They assist the judges in reviewing docs, but also handling the sales. So in Ohio, we get judgment, we file a precipice. In Kentucky, they're more intertwined. We file a motion for judgment and order of sale. So it's one motion, it gets granted, and then it automatically goes to the master commissioner to handle. The master commissioners will handle advertising the sale, having the property appraised. They don't do it personally, they do similar as Ohio. They have 3 disinterested appraisers appraise it. Then the master commissioner will conduct the auction. There is no minimum bid. However, the two-thirds appraisal does matter. If you bid below the 2/3, the homeowner has 6 months afterwards to redeem the property. As far as additional liens, similar to Ohio, you can initiate a foreclosure being the senior or junior lien holder. Senior mortgage holders also have the right to file an answer requiring that the sale be subject to their mortgage. It works exactly the same way as Megan just described for Ohio. If they do that, their lien will not be extinguished through the foreclosure. It survives, but that means the junior lien holder will be paid first in proceeds rather than the senior. If they don't file an answer requesting the subject to, they'll just be paid in their priority. So senior will be paid ahead of the junior liens. The first person who's paid, of course, is the master commissioner. So all the costs, the court costs, they're paid first. Then taxes are paid. Then it goes down to the lien holders. The junior lien holders, their liens will be extinguished through the foreclosure sales. So Kentucky post sale, one of the more challenging things I'd say in Kentucky is just that every master commissioner has their own way to do things. So in some counties, the master commissioner handles the whole post sale process. They prepare the confirmation, they handle the deed. In other counties, the master commissioner may only do the confirmation, we do the deed. Other counties, the master commissioner is kind of hands off. We prepare everything, send it over to them, and then they execute it. I personally would prefer to do it ourselves because then we can get everything moving a little quicker. I feel like in the counties where the master commissioner does all the steps, you know, we can follow up, you know, gently nudge them, hey, what's the status? But ultimately, the master commissioner is going to get it done when they get to it. So in those counties, I feel like the delay is a little longer on getting everything confirmed, getting the proceeds, getting the deed. So I prefer to do it myself personally, but it's not up to us, unfortunately. If we file an answer in a foreclosure, say the senior lien, junior lien holder initiates the foreclosure, we can file an answer, move along, and just monitor the action. Some counties, they will require you to file an answer cross-claim or amend your answer to assert a cross-claim in order to get proceeds. It's not all counties. Some counties you can file the answer, and then the master commissioner will include you in the distribution. Some master commissioners may ask that you file an additional motion to distribute, then they will send you the proceeds. In the hardest counties, they make us actually proceed with the cross-claim, get judgment, and then we can move for the proceeds. So again, it kind of varies just depending on the court. But generally, if we know there's going to be proceeds, you know, we look at it, there's a ton of equity. We know the county will require a cross-claim in order to get the distribution. We will recommend to the client, hey, instead of doing an answer, let's do an answer cross-claim, because we'll need to get judgment in order to get the proceeds that are inevitable anyways if it goes to sale. Other times it may make more sense to only file the answer. That way we keep the fees and costs low in situations where it's very close. You know, the senior is owed 200,000, the property looks to be valued around 200,000. In those situations, it likely makes more sense. We'll file the answer, we'll monitor. If there are proceeds, okay, we'll let you know there's proceeds, then we can move at that time. If there's none, it's to the benefit of the client, because we have not incurred a bunch of additional fees and costs that are never going to be recovered.
And Ricardo, could you list some of the counties that you know that do require that cross-claim?
The largest one is Jefferson, which is Louisville. They always require it. As I discussed earlier, Kentucky does have a redemption period. Here I listed the actual statute, but the gist of it is it gets appraised. 2/3 of that appraised value is what must be bid to eliminate the defendant's 6-month right of redemption. So this is crucial when it comes to the bidding strategy. If your total debt, including like what we expect to be the taxes and the master commissioner, are under 2/3 of the appraisal, I mean you just aren't going to bid that. You can still bid your total debt, and you'll just have to deal with the 6-month right of redemption. However, if your total debt is exceeds the 2/3, if I get a bid that's slightly under the 2/3, I always recommend to my client, hey, push it up another 5,000. This will save you 6 months of sitting on this property during the defendant's right of redemption. It'll save the clients a great deal of money and time if they just push their bid up to the 2/3. Like I said, it's not always possible, but in most instances it is. So that's my recommendation there. And then the next state I'm going to discuss is Michigan. I'm familiar with the process and everything. I'm not licensed in Michigan, but I'm very familiar with the process. Michigan is our only non-judicial state that we handle in footprint. Very, very different as far as the timeline, as well as the procedure. A non-judicial foreclosure doesn't go through the court system. Instead, the property is conveyed to what's known as a trustee. And this is generally allowed through a clause in the mortgage. Unlike the 2 states we've already talked about, Ohio and Kentucky, you're not filing a complaint with the court. The first legal document is actually the foreclosure notice that's advertised in the newspaper. The first legal date would be considered the first date that the newspaper is published in the paper. So the newspaper or the publication goes on for 28 days. And after that notice, the sale can occur on the next available date. And that's set by the county's schedule. The foreclosure sale is similar to the judicial sales. It's still an auction. It's open to anyone. It's held in a public place. Unlike the other 2 states we've already discussed, in Michigan, the opening bid must be made by the party that has initiated the foreclosure. If not, the sale won't go forward. So in Michigan, if you're bringing the action, you have to place a bid. Regarding the additional liens, they can also be initiated by either the senior or the junior lien holders. If a foreclosure is initiated, though, by a junior lien holder, the senior lien will not be extinguished. It's not a judicial, so then the senior liens aren't required to file an answer or take any action. their liens are protected, so they're not going to be extinguished. However, junior liens will be extinguished following the expiration of the redemption period. Post-sale, once the sale occurs, the sale is final. There's no judicial process to vacate sales, but lien holders instead must file claims for the excess proceeds, or the proceeds may be dispersed to borrowers and the creditors lose out. The sheriff of the county will handle filing the deed and turning over the excess proceeds. And here the redemption period in Michigan starts after the foreclosure sales occurred. All the parties, so primarily like junior lien holders that had an interest in the property, have a period of time to repurchase the property from a successful purchaser. So one party bids 50, the other lien holder can then do like what I consider an upset bid more to become the purchaser. The redemption period can either be 6 or 12 months, depending on the size of the property and the percentage of the original loan balance that was paid by the borrowers before the foreclosure. And if there's ever any questions regarding the Michigan redemption process or any questions, please just feel free to reach out to us. We'll get you the answer you need. Indiana sales would jump back into the judicial world. Indiana sales are I'd say fairly similar to Ohio sales. You go through the process, you file your complaint, you get judgment. Same as in Ohio, after judgment, you'll file a precipice for an order of sale. In Indiana, the sales can go through the sheriff, but sheriffs are allowed to contract with outside companies to hold the auction. Probably 10 years ago, it was a good split. Half the counties handled them internally by the sheriffs. The other half contracted with the company outside. Today, completely flipped. There may only be, that I'm aware of, 1 or 2 counties where the sheriffs still handle the sale. They've almost all primarily contracted out with a company called SRI Services, and SRI will handle conducting the auctions. The auctions still can either be in person or held online. The sheriff will still handle the advertisement. They have to be advertised. The sale notice has to be advertised for 3 consecutive weeks. Unlike the other 2 judicial states of Ohio and Kentucky we discussed, these properties are not appraised, and there is no minimum bid. So this is very important. You cannot bid if you're a lien holder, but you're always risking this could sell for $1. The winning bidder would still have to pay the court costs and taxes, but if you place no bid, you're losing your lien for nothing. So it's important, in these matters, to have a good BPO for the client so that they know ahead of time, here's what we value the property at, so they know what to bid as far as their total debt. Another nuance of Indiana is taxes are not paid after the sale. You have to pay taxes prior to the sale. If taxes aren't paid prior to the sale, we'll get contacted by either the sheriff or the SRI letting us know, hey, please provide us proof of payment, treasurer showing taxes are still due. So we'll reach out to the client, which we already do. When we get the notice of sale and everything, we reach out to the treasurer, we get the tax amount through the sale date. So we'll send the clients a notice. Here's the tax amount, here's who needs to get paid, here's where to send the payment. So we'll send that, ask for the bid. We always ask to get confirmation that, once taxes are paid, can you please let us know? So if we get notified, sometimes we can go to the treasurer and say, hey, check was already mailed. Here's the tracking information. You should have it in a day or two. Occasionally, something slipped through the crack, and our clients have to overnight the tax payment to the treasurer. Because if they're not paid, the sheriff will cancel the sale. As far as the additional liens in Indiana, they can be initiated by the senior or junior lien holders. The seniors, they also have the subject to requirement. It works exactly the same as in Ohio and Kentucky. Just if it goes through, whoever takes this property is the winner. This mortgage is still going to be on your property. So it's very important as far as the bidding strategy, to know what the seniors do, which can be very hard in sometimes because the protections. A lot of senior lien holders won't provide us their exact payoff without borrower authorization. Well, it's next to impossible to get borrower authorization when we're foreclosing on someone. So in most of the time, it's a ballpark figure, either through maybe a credit report that was pulled, or we'll use the information that the senior filed. Generally, when a senior files and subject to answer, they do let us know in their answer the principal and the interest amount. We don't always know, hey, was there escrow? Were there other fees and costs in here? So sometimes we have to ballpark it. We will always reach out to the seniors, try to get their payoff. They don't always provide it. If the senior doesn't request the sale to be subject to their mortgage, then the senior will be paid ahead of all the other liens. Taxes have already been paid, but court costs will still get paid ahead of the lien holders. Junior liens, they are extinguished through the foreclosure sale. Post sale, Indiana is unique compared to Ohio and Kentucky. In Indiana, there is no confirmation of sale. Instead, you file a clerk return that just outlines the distribution of proceeds. That's part of the sale packet. So when you send the return, or you send your sale packet to the sheriff or to SRI, it includes the clerk return that we have to prepare based on our client purchasing it at the bid they provided. So then you'll have the outline. Here's the court cost, taxes have already been paid. Here goes to this lien holder. Here goes to our lien holder. And that's how it works. Occasionally, it may sell third party for more. So then we have to send an updated clerk return where we adjust the amounts. So sometimes we do it twice, but that's still much quicker than filing a motion in Ohio or waiting for the master commissioner to prepare the confirmation themselves. So Indiana post sale is just a clerk return, so it's very fast. Once the sale happens, that's it. The borrower can redeem up to the day of sale, but there's no post sale redemption. After the sale, the sheriff will execute the deed and distributes the proceeds after the sale. And he's basically working off the clerk return. He's just dispersing it, whatever the clerk return said. Similar, if we file an answer in a third-party foreclosure, sometimes if we're the junior lien, sometimes we're able to, or the other side will include us in their distribution. The majority of the time, though, the clerk return will say, the remaining funds to be dispersed with the court for further order. In those situations, we'll get an affidavit from our clients stating, the amount they're due through the sale. We'll file a motion for distribution, asking that the court send us our, whatever's due to us out of the sale proceeds. All right, I'll pass it on to Casey.
Yeah, I think that's it for you, Ricardo, right? So,
Yeah.
right now, so now we're jumping over to Illinois. And Illinois has some different nuances that we'll go through today when we talk about the lovely state of Illinois. In Illinois, you can foreclose from the junior or the senior lien position. Illinois is different from the other states that we've discussed today. If you're foreclosing from the junior lien position, the senior lien is not named. They do not have an opportunity to file an answer and ask that the property be sold subject to their lien. It automatically is sold subject to their lien. Senior liens are not extinguished in a junior lien foreclosure, and the senior lien must be paid off by the successful purchaser at the foreclosure sale. Similar to what Ricardo was talking about, we can attempt to obtain payoff information from the senior liens, but a lot of times they do need the authority from the borrower to release that information to a third party. So a lot of times that information is not made available to us, but we do try to obtain those payoffs if our clients are the successful purchasers at a junior lien foreclosure. The redemption period in Illinois is also a little bit different. There's a redemption period prior to the sale, and in some circumstances after the sale, which we'll get into in a little bit. But the redemption period prior to the scheduled sale, that is set within the judgment of foreclosure and sale. And typically that is going to be 7 months from the date that all parties within the foreclosure have been served, or 3 months from the date of entry of the judgment. Typically, by the time we're getting to judgment in Illinois, it is going to be that 3-month date. A lot of counties in Illinois have mediation programs, or in Cook County, they have their case management system where you must have a case management hearing before you can move for judgment. So some of our timelines are a little bit more delayed. We're typically seeing that 3-month redemption date from the entry of judgment. If the property is abandoned, if no one is living there, that pre-sale redemption period can be shortened to 30 days at the time of judgment. If the client believes that the property is abandoned, we typically will work with our process server or one of our vendors to obtain a report of the property and an affidavit that indicates the property is abandoned. Then we will file a motion to shorten the redemption period at the time of judgment. The redemption date is set explicitly in the judgment of foreclosure, and then we work with the selling officer to schedule the sale for typically the day after that redemption expires, or as soon as possible. During the redemption period, we go ahead and coordinate the notice of sale being sent to all the parties and the sale publication. The publication of the sale has to be published once a week for 3 consecutive weeks prior to the sale. And that sale publication is good for 60 days. So for example, if our scheduled sale is set for November 1st, and for some reason we want to continue that sale, the client asks us to continue that sale, we can continue that sale date for up to 60 days under that same publication. We don't have to republish. So at the original sale date of November 1st, there's an announcement made that the sale is then continued to January 1 or whatever date it's continued to. The sale cannot be continued for more than 60 days without restarting the sale publication process. In Illinois, sales are either held by the county sheriff or a private selling officer. Most of our counties in Illinois have moved over to a private selling officer. There's a few different ones within Illinois. We moved to appoint that selling officer at the time of the judgment. There are still a few counties left that only allow the sheriff to conduct the foreclosure sales. Those sales are a little bit more cumbersome. They just require more steps on our part to make sure that the sheriff has all of the information that they need prior to conducting that sale. Illinois is also a little bit different than some of the other states that we've discussed because the plaintiff does have to open bidding at the foreclosure sale. They do the initial bid. So they have different options that they can do to decide, how they want to bid, open the bidding at a foreclosure sale. The max amount the bid can be is full debt. So a full debt bid in Illinois is the amount that's itemized in the judgment of foreclosure and sale plus sale publication and selling officers costs. And then depending on the amount, if it's less than $25,000, it would include 5% interest from the date of judgment to the date of the sale. If the judgment amount is over $25,000, it accrues 9% interest from the date of the judgment to the date of the sale. So when the bids are coming in from the clients, we're always double checking to make sure that the bid is not over full debt. Because what happens is if the bid is over full debt, it results in a surplus, which there's no reason to have a surplus that the borrower could potentially petition the court to recover for. So we're always going to let the clients know if their max bid is over what they can bid. Now, what also is different in Illinois is there's no minimum bid. The plaintiff can open the bid with whatever bid that they want that is deemed reasonable. And that, of course, spans a wide variety of amounts that it could be. We do not have the 2/3 appraisal rule in Illinois that are in other states that have been mentioned today. We have the reasonable value of the property that the property can be sold for. Also in Illinois, anyone can bid at foreclosure sales. They're open to the public. So a junior lien holder could bid, a borrower could also show up at the sale and also bid at the sale. And then any member of the public could show up at the sale and also bid. After the plaintiff opens the bidding, if there's competitive bidders that are there at the sale, the next bid is usually $1 over that opening bid that the plaintiff has made. If there's multiple people bidding on the property, it typically will then go in increments of either 1,000 to 5,000, depending on the number of bidders and how aggressive they are being with their money that they want to use to buy this property that's for sale. If you're a junior lien holder that has been named in the foreclosure, you can also bid at the foreclosure sale. If your lien has been itemized within the judgment, you can potentially credit bid at the sale and you would not need to have the required deposit. But typically, for most of the selling officers in Illinois, you need a 10 to 25% of your maximum bid in the form of a certified check on the day of the sale. The remaining balance, if you're the successful bidder, will be due to the selling officer within 24 hours. Typically, the selling officer provides wiring instructions, and then we help coordinate with our clients to get the remaining amount over to the selling officer within that 24-hour period. A lot of times, the selling officers or the sheriffs, they're not listing the opening bids prior to the sale. So anyone that's coming to potentially bid on a foreclosure sale really has no idea what the bid will be opened at, because that again is determined by the plaintiff, and it could be their full debt, or it could be a lower amount. So there's a little bit of research that has to be involved with bidding, and then a little bit of strategy as well, just because it's a little bit unknown what that opening bid might be. Junior lien holders will also want to evaluate the value of the property, and then also determine, the amount of that senior lien if they are bidding at the foreclosure sale, just to help try to determine what they think the opening bid might be. I touched on surplus just a little bit a couple of slides ago, but if the plaintiff opens their bidding at full debt and then there's competitive bidding, then there's obviously going to be a surplus. So the full amount of the debt that's owed to the plaintiff will be paid first. And then if junior lien holders have proved up or itemized out their lien within the judgment of foreclosure, then they could petition for the surplus next to be paid off from that surplus. If there's no junior liens within a particular foreclosure and a sale has resulted in a surplus, the borrower can petition to have that surplus turned over to them. So that's kind of a nuance in Illinois as well that's not in a lot of other states. There's very specific requirements as well in Illinois for junior lien holders to prove up or have their lien be included in a judgment of foreclosure, and their lien must be specifically itemized in the judgment of foreclosure to be able to petition for a surplus at the conclusion of a sale. So it's very important in Illinois for junior lien holders to be active if they are named in a senior lien foreclosure. And what I mean by being active is it's important to file an appearance and an answer and an affidavit of proof up. That way, all of the information about your lien and the amount of your lien is included on the court record. And then we work with plaintiff's counsel to ensure that that specific itemization is in the judgment of foreclosure when that order is entered. Now, getting to the special right to redeem, which is a post-sale redemption period in Illinois. If the plaintiff purchases the property at the foreclosure sale and the sale price was for less than the amount that the plaintiff owed, so less than a full debt bid, the borrower then has a special right to redeem of 30 days. And that 30 days is 30 days from the date of the sale. And the borrower must pay to the plaintiff the sale price, any additional costs, and interest from the date that the purchase price or the sale date, the purchase price was paid, or which is the sale date. We do have a sale confirmation process in Illinois. The plaintiff files that motion once we receive all of the documents from the selling officer. Those documents include a report of sale, a certificate of sale, and a receipt of sale. We typically get those documents within a week, most of the time from the selling officer. Sometimes the sheriffs are a little bit slower. The statute in Illinois regarding sale confirmation says the court shall confirm the sale unless there's 4 specific things that haven't happened. Notice was improper, the sale was unconscionable, the sale was fraudulent, or justice was not otherwise done. So just to elaborate a little bit on some of these, notice, obviously that's a big one, but we are always ensuring that our notice is proper. We won't go forward with the sale if there was some sort of error with the notice. It's very rare that that would even happen. Unconscionable sale terms. This is also a rare one. It could potentially happen if the value of the property is quite high and then for some reason the plaintiff decided to open bidding at a very, very low amount. Also rare. Fraudulent sales, again, also not something that really happens. And then this 4th one is kind of like a catch-all for anything else, justice not otherwise being done. But again, if notice is proper, sale terms are, fine, there's really not a reason for the court to not confirm the sale. So it is a very rare occurrence that the confirmation of sale is going to be denied in Illinois. Within the confirmation order, possession is awarded to the purchaser within 30 days. So sale has happened, confirmation happens, but that successful purchaser cannot take possession of that property for 30 days. If there is some sort of issue with the property, if there's a dangerous and hazardous condition, if it's abandoned, we just need to know that because we can also file a motion for immediate possession in conjunction with that sale confirmation motion so that we could put our client in possession of the property right away so that the property doesn't, diminish in value anymore. Also within sale confirmation, we can, if the property was sold for less than full debt, we can pursue an in personam deficiency judgment against the borrowers, which would just mean a money judgment has been entered against the borrowers for any remaining amount that's owed, or just an in rem deficiency judgment, which basically just is, you can't collect it from the borrower after that. That concludes our presentation today. If anyone has any last minute questions that they want to put in the chat, we can answer those. Otherwise, all of our contact information is right here. If you think of a question, maybe later today while you're thinking about foreclosure sales, feel free to reach out to us. We'd be happy to answer those. We want to thank you all so much for attending today's webinar. We hope that you found it informative and it gave you a little bit more information about the differences between the sale processes between the states that we discussed. As a reminder, there's a short survey that will pop up on your screen. Please share your feedback with us. Let us know what you thought of today's topic. And again, if you have any other suggestions for topics that you might want us to discuss in future webinars, please let us know. We do have a few upcoming webinars, one being Coffee with Casey. We'll be talking about probate and collateral recovery. That's on November 13th. So I hope you guys sign up. And thank you again for attending. I hope you guys have a great rest of the day. Thanks, Megan. Thanks, Ricardo.
Thanks.
Thanks, everyone.